Listen to me very carefully, because what I am about to tell you is the kind of information that the financial advisors, the lawyers, and the government-dependent middle class never bothered to learn. And it is costing ordinary, hardworking, law-abiding Americans their freedom, their savings, and years of their lives. Your car is the worst place to store a gun. And I do not mean worst in some vague theoretical sense. I mean worst in the precise, documented, legally devastating sense that results in 3 years of your life consumed by a legal system you thought was on your side because you did everything right. I have spent my entire career teaching people that the rules of money are different from what school teaches you. What I am going to show you today is that the rules of constitutional rights work exactly the same way. Knowing you have a right and knowing how to defend that right are two completely different things. One is opinion, the other is survival. And I do not care about your opinions, I care about your survival. Before we go any further, I want to be direct with you. The information I am about to deliver has kept prepared, educated, financially intelligent people out of courtrooms, out of legal fees, and out of the devastating financial drain of fighting the government with their own money. Rich Dad always told me that the people who win in this world are the people who understand the rules of the game before they play it. Right now, you can get that understanding for free. Subscribe to this channel and turn on every notification. Share this with every gun owner in your circle. Drop a comment with the word prepared so I know who is serious and who is just watching. This is not entertainment. This is education that the system never gave you and that I am giving you right now at zero cost. The next ruling that affects your rights is already moving through the courts. You will either be ready for it or you will be paying someone else to explain it to you after the damage is done. I want to tell you why I understand this subject with a depth that most people who have law degrees do not have. And it comes back to everything Rich Dad taught me about the difference between the educated and the intelligent. Poor Dad believed in the system. He trusted that if you followed the rules would protect you. He spent his career inside institutions built by other people's frameworks, and when those frameworks failed him, he had no backup plan because he had never been taught to think independently of the system. Rich Dad taught me something completely different. He taught me that the rules of every game, money, law, business, investing, are written by people who benefit from the rules being followed by everyone else while they themselves understand the exceptions, the leverage points, and the vulnerabilities. Rich Dad did not break laws, but he understood them at a level that the people who merely obeyed them never reached. When I built my first real business, I learned very quickly that there are people who sign contracts and people who understand contracts. The people who sign without understanding are always at the mercy of the people who understand what they signed. I have watched this exact pattern destroy financially comfortable, responsible, genuinely law-abiding gun owners who thought the Second Amendment was a force field. It is not a force field. It is a right. And rights only protect you when you know precisely how to exercise them. The man I'm going to describe to you today had a valid permit, a registered firearm, 40 years of responsible ownership behind him, and the full weight of a constitutional guarantee in his corner. And it still cost him 3 years of his life, not because the law failed him at the macro level, because nobody had shown him the specific operational detail of how that law worked and did not work at the moment of a traffic stop. That gap, the gap between knowing you have a right and knowing how to use it, is the same gap that keeps most people broke their entire lives, while they wonder why the system never worked for them. Here is the foundation you need to understand before anything else makes sense. The United States Constitution gives every American two protections that are supposed to exist simultaneously, side by side, without conflict, on every road in every state in this country. The Second Amendment gives you the right to keep and bear arms. That is not a privilege extended by a government agency. That is not something you earn or apply for at the pleasure of a bureaucrat. It is a constitutional guarantee that over 100 million Americans exercise lawfully every single day. Now run a parallel to financial assets. Think of the Second Amendment as a title deed. It says clearly and in writing that this asset belongs to you. The Fourth Amendment gives you the right to be free from unreasonable searches and seizures. No government agent can go through your vehicle, your home, or your personal property without either a judicially authorized warrant or specific, legally defined probable cause. Think of the Fourth Amendment as the lock on your vault. It says that your private property cannot be accessed without specific legal authorization. Two rights, both clear, both constitutional, both in writing, both supposed to be operational simultaneously. What happened in courtrooms across this country, quietly and without national debate, is that the presence of a legal firearm was being used by some courts to justify stripping gun owners of their Fourth Amendment protection. The legal reasoning being constructed went like this. Firearms are inherently dangerous. Therefore, a firearm in a vehicle creates an inherently unsafe situation. Therefore, the officer has automatic search authority regardless of whether any actual crime has been committed or suspected. Follow that logic to its conclusion, and you reach the place where exercising your Second Amendment right simultaneously voids your Fourth Amendment right. In financial terms, this is exactly what happens when a bad contract clause says that in the event of X, you waive all claims to Y. Most people sign those contracts without reading them. Most gun owners were driving through this constitutional trap without knowing it existed. The Supreme Court just issued a 9-0 ruling, minus justices, 0 dissents, every ideological position on the bench unified, saying that a legal firearm does not by itself constitute probable cause to search a vehicle. The numbers are that clear. Armed does not mean criminal, 9-0. Now, here's where I slow down and get precise, because this is the section where most people make the exact mistake that transforms a legal victory into a false sense of security. And false sense of security is one of the most expensive financial conditions a person can be in. I have watched people go bankrupt because they thought one legal protection covered every scenario. It does not. The 9-0 ruling contains a phrase that carries the entire weight of the protection's limitations. And that phrase is by itself. The mere presence of a legal firearm does not by itself constitute probable cause. By itself, those two words are the boundary line of this protection, and you need to understand the three specific places where the protection stops and your exposure begins. The first vulnerability is your legal status, and this one is non-negotiable. This ruling protects people who are legally entitled to possess a firearm. If you have a felony conviction, a domestic violence restraining order, or any other disqualifying factor, the gun in your vehicle is evidence of a crime in progress, and the ruling is completely irrelevant to your situation. In financial terms, think of legal eligibility as your credit score. The entire financial system extends to people with good credit in ways that it does not extend to people with damaged credit. This constitutional protection extends to people with clean legal status in ways it does not extend to prohibited persons. Know your own status with complete certainty before you get behind the wheel with a firearm. The second vulnerability catches genuinely responsible, law-abiding gun owners who simply did not do the homework, and it is entirely preventable if you treat legal preparation with the same seriousness you treat financial preparation. Many states have specific statutory requirements governing exactly how a firearm must be stored inside a vehicle. Some require it to be unloaded, some require a locked container, some restrict the physical location within the vehicle. These are not suggestions, these are criminal statutes. If an officer observes a firearm stored in direct violation of your state's storage law, he is not searching based on the presence of a gun. He is responding to a specific, observable violation of a criminal statute. The 9-0 ruling does not protect you in that scenario because the probable cause is not the gun, it is the illegal manner of storage. Rich Dad always told me that ignorance of the rules is not a defense against the consequences of breaking them. You would never invest in a business without reading the relevant regulations. Do not carry a firearm without reading the relevant storage laws of every state you drive through. The third vulnerability is the most sophisticated and the one where innocent, completely law-abiding people get caught. The ruling stopped officers from using a legal firearm as the sole justification for a search. It did not stop them from using it as one factor among several. If your firearm is legal, but your passenger is visibly nervous and giving contradictory answers, and there is an unusual smell in the vehicle, and your own statements about your destination are inconsistent, the officer is not going to argue in court that he searched because of the gun. He is going to argue that the gun, combined with the behavior, combined with the physical environment, combined with the inconsistent statements, collectively establish probable cause. That argument can survive legal challenge. The protection the Supreme Court just handed you is powerful and real, but it is not a blanket immunity from every search. It is a specific protection against a specific overreach. Know the distinction before you need it. The most dangerous moment of any traffic stop involving a firearm is not when the officer first approaches your window. It is not when he sees the weapon. It is not when he asks for your license and registration. The most dangerous moment is when the officer realizes he does not have enough to legally justify a search, and so he tries to get you to hand him permission voluntarily. And this is where I want to speak to you with the urgency I reserve for the most financially devastating mistakes I see people make, because the parallel is exact. In my decades of business and investing, the single most common way I have watched people hand away assets, equity, and legal rights is not through theft and not through fraud. It is through voluntary consent under social pressure. Someone puts a document in front of you and the social dynamic of the situation makes saying no feel impolite, suspicious, or uncooperative. So you sign, you agree, you hand over something that was yours to protect because the moment felt too uncomfortable to hold the line at a traffic stop with a firearm in your vehicle. That moment looks like this. The officer says calmly, professionally, and with the tone of someone simply doing their job, "Since you have a firearm in the vehicle, for your safety and mine, do you mind if I just take a quick look through the car?" That sentence is not an innocent procedural question. That sentence is a carefully calibrated psychological mechanism designed to convert your constitutionally protected right into a voluntary permission. It is designed to make declining feel like you have something to hide. It is designed to make the cooperative, law-abiding person in you override the legally protected citizen in you. Do not let it work. The moment any version of consent leaves your mouth, "Yes, sure, go ahead, I don't mind, I have nothing to hide," the 9-0 Supreme Court ruling becomes completely irrelevant to your situation. Consent overrides the court. Consent overrides the Constitution. Consent is a waiver of the Fourth Amendment's protection that cannot be undone in any courtroom by any attorney, regardless of how clearly the search violated the spirit of your rights. In financial terms, this is the equivalent of verbally agreeing to loan modification, terms that gut your original contract. The original contract protected you. Your agreement to the modification overrides it. Rich Dad never signed anything under social pressure. He would slow the transaction down, step back from the social dynamic, and make the decision from a position of calm clarity rather than in-the-moment discomfort. That is exactly what you must do at a traffic stop. Respond briefly and calmly. "I do not consent to searches." Then stop talking. Do not argue. Do not explain. Do not cite the Constitution. Do not reference this video or this ruling. State your position simply, clearly, and then exercise the constitutional right that costs you nothing and protects everything. Silence. I want to give you the complete 8-step protocol, because a principle without a procedure is just an idea, and ideas do not protect you on the side of a highway at 10 o'clock at night. Rich Dad always told me that financial intelligence is worthless without financial discipline, and the discipline comes from having a clear, repeatable system that you execute the same way every single time, regardless of the emotional pressure of the moment. This protocol is your balance sheet for a traffic stop. First, pull over immediately and correctly signal your intention. Slow down smoothly and move to the right shoulder without hesitation. A slow or uncertain pullover creates tension before you have said a single word, and tension is the enemy of a clean interaction. Second, control every variable in the physical environment. Before the officer reaches your window, turn off the engine, roll the driver's window fully down, Roll any tinted rear windows down as well, because visual uncertainty makes officers tense before a single word is spoken. At night, turn on your interior dome light so your hands and the interior of the vehicle are clearly visible. Then place both hands flat on top of the steering wheel and keep them completely still. Do not reach for anything until the officer is at your window and you have verbally communicated every movement you are about to make. Third, speak before you reach. When the officer requests your license and registration, do not immediately move toward document storage. If your firearm is anywhere near your glove box, your center console, or any other location where your documents are stored, an unannounced movement in that direction is exactly how calm interactions become dangerous ones. Verbally tell the officer first, I have a legally owned firearm in the vehicle. I want to fully cooperate, and I want to ask how you would like me to proceed. That communication does three things simultaneously. It demonstrates proactive, complete cooperation, it eliminates surprise, and it establishes you immediately as a responsible, protocol-aware gun owner who is not a threat. Fourth, know your state's duty to inform law before you ever drive with a firearm. Some states legally require immediate disclosure of a firearm to a law enforcement officer upon contact. Others have no such requirement. This is not uniform across the country. It varies by state. If your state requires disclosure, disclose immediately and without elaboration. If your state does not require it and the firearm is not visible, you have no legal obligation to volunteer that information unless you are directly asked. And if you are directly asked, never lie. A single false statement to a law enforcement officer can transform a routine traffic stop into a criminal matter with consequences that dwarf anything that might have come from the original stop. Fifth, refuse consent calmly, briefly, and completely. When the officer asks whether he can look inside your vehicle, your response is simple. I do not consent to searches. That is your entire statement. No explanation, no argument, no legal citation, no emotional elaboration. State your position clearly and then be quiet. Sixth, use silence as a deliberate, strategic tool. Silence is a constitutionally protected exercise of your Fifth Amendment rights. It costs you nothing. It cannot be used against you, and it removes every building block an officer might otherwise use toward establishing probable cause. Most people talk their way into searches that would never have occurred if they had simply stayed quiet. Every sentence you volunteer is a potential piece of a probable cause mosaic. Remove the pieces by removing the words. Seventh, if a search occurs anyway after your clear refusal, do not physically resist under any circumstances. State calmly and clearly, loudly enough for any recording equipment to capture that you do not consent to this search. Say it once, then stop. Do not repeat it. Do not escalate. Your composure in that moment is the foundation of your legal case going forward. Every piece of evidence found in a search that had no legal justification is now a potentially suppressible in court. Let the officer's actions tell the story. Your job is to not provide any additional narrative that complicates the legal picture. Eighth, document everything. The moment the stop ends, pull over somewhere safe immediately and write down every detail while your memory is still accurate. The exact time and location, the officer's full name and badge number, the precise words exchanged around the firearm, the precise words exchanged around any request to search, whether you consented or clearly refused, whatever justification, if any, was offered for the search, what was or was not found. Human memory degrades fast, and it degrades selectively in the direction of what we wish had happened rather than what actually occurred. Contemporaneous documentation, written within minutes of the event, is the foundation of winning legal cases. Vague general recollections written weeks later from memory are what cases get lost on. The numbers don't lie, and the number of cases that turned on documentation versus the number that turned on memory is not close. Here is the question I am leaving you with, and I want you to answer it honestly because the answer determines everything that comes next in your financial and personal life. Are you a winner or a loser? I do not ask that to insult you. I ask it because it is the only binary that matters in every area of life that affects your freedom and your finances. A winner is someone who learns the rules of the game before they play it. A winner is someone who prepares before the moment of pressure rather than reacting during it. A winner is someone who treats constitutional rights the same way Rich Dad taught me to treat financial assets, with respect, with knowledge, and with the disciplined systems necessary to protect them. A loser is someone who drives around with a firearm and assumes that having the right means being protected by the right. Automatically and without preparation, a loser is someone who hands consent to an officer because the social pressure of the moment overrode the legal protection they technically possessed. A loser is someone who hears this information and does nothing with it. You're broke and you don't even know it applies to legal rights as much as it applies to bank accounts. Most people are constitutionally poor. They possess rights on paper that they cannot exercise in practice because they never took the time to learn the operational reality of how those rights work and where they fail. The 9 justices who unanimously agreed on this ruling handed you a tool, a real powerful, documented legal tool. But tools only produce results in the hands of people who know how to use them. Stop being a victim of your own ignorance. Subscribe, share this comment, and go learn the storage laws of every state you drive through before you put the car in reverse with a firearm in that vehicle, because the next stop is coming, and when it does, you will either be prepared or you will be paying